Good evening and welcome to the Kent County Board of Adjustment meeting for June 16th, 2022. At this time, I'm calling the meeting to order. When you're ready, will you call the roll?
Yes, ma'am. Miss Hudson?
Here.
Mr. Nichols?
Here.
Mr. Jenkins?
Here.
Mr. Cusick?
Here.
Miss Denny?
Here.
That's 5 present, ma'am.
Thank you. So we have a quorum, and if you would introduce the staff.
Yes, ma'am. My name is Jamie Fensky, and I'll be the planner tonight for the Board of Adjustments meeting. I have with me Mark Kennedy, our IT staff, and Mr. Fred Townsend, our legal counsel.
Okay, at this time, I'm going to ask everyone to rise so we can pledge allegiance to our flag. Okay, any additions or alterations to the agenda?
No, ma'am.
Okay, so at this point, introduce the public hearing, please.
Good evening, ladies and gentlemen. My name is Jamie Fensky, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on the application and the old business before the Kent County Board of Adjustment. Everyone will have an opportunity to speak. This will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there should be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony. The chairperson of the board has the discretion to allow additional time if deemed to be necessary. To make statements when your application is called, and for the record, please give your name, address, and allow our attorney to swear you in prior to providing testimony. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each variance application will be as follows. The legal notice will be read on each case prior to the receipt of testimony. There will be a brief explanation of the application by the staff. The board will then receive testimony from all of those in favor of the application, followed by testimony of those who may be opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on all applications heard this evening will be made by the board during the business meeting following the public hearing. However, you are not required to remain after the public hearing once your request has been heard and closed. During the business meeting, the board will consider all information of record, and a common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471, or check the Kent County Planning Department website to learn of the board's ruling. All applicants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your record for both you and all future property owners. The public notice of this evening's hearing was published on May 29th, 2022 in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications.
Okay, thank you. At this time, we're going to have a statement by counsel, the purpose of which to help those who are going to give testimony this evening an opportunity to understand what's acceptable as testimony before this particular body. Mr. Townsend.
Thank you, Ms. Denny. The Delaware Supreme Court has established the standards for the granting of area variances in the case known as Board of Adjustment versus Quick Check Realty. The legal standard applied to applications for area variances considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. In order to determine whether exceptional practical difficulties exist, the board must weigh the following 4 factors. 1, the nature of the zone where the property lies. 2, the character and uses of the immediate vicinity. 3, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And 4, whether failure to remove the restrictions would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. The test is satisfied only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. Note that economic hardship may constitute a legitimate exceptional practical difficulty. The inability to improve one's business or stay competitive as a result of area limitations may justify a variance. In general, the board is not permitted to consider factors other than the ones I listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on 1, the nature of the zoning district, 2, the characteristics of the area, 3, whether the requested variances would seriously affect neighboring properties, and lastly, whether the applicant is confronted with challenges rising to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from their presentations any discussion of disputes or acrimony between the applicant and neighboring property owners, as the board is both unable and unauthorized to resolve those disputes. Presenters must limit their remarks to those issues that the board can decide. That's my statement, Ms. Denny.
Thank you, Mr. Townsend. So when you're ready, let's start the public hearing.
Yes, ma'am. So first we have application A-22-16. This is for a parcel that's zoned to AC. The variance is from the 23% maximum impervious surface coverage and from the minimum lot width of 150 feet at the front building line. The present use is church, proposed the same. It's in the Levy Court District 3rd for Mr. Angel, located on the south side of North Little Creek Road, approximately 445 feet east of Fox Road, east of Dover. Here you will see the proposed layout. So the existing property lines there in blue. The proposed will be red, so they're kind of evening out the parcels a little bit better. The parcel 0101's proposal is to have a total acreage of 8.45 acres with impervious area of 2.27 acres. The percent impervious would be 26.9, and again, the permitted is 23%. Parcel 01.05 would have a total acreage of 5.86 acres, impervious area of 0.98 acres, with a percent impervious of 16.7. This is for the front, the minimum lot width of 150 feet at the front building line. So the front setback for this parcel is 75 feet. The width there would be 64 feet, is what they are proposing. This is looking at the parcel from the road, down the road, in the other direction. Again, back at the front of the parcel. This is just showing some of the improvements on the parcel and towards the rear. And the aerial. So ma'am, if you want to come forward, state your name and address and allow our attorney to swear you in.
Dana Dunphy, 550 Bay Road, Dover, Delaware.
Ms. Dunphy, do you swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes. I'm here representing the church and William Darby, who operates the pole building in the back. We are proposing a lot line adjustment to allow for Mr. Darby to have his own parcel for his business, which is the ProCut Tree Services. We came before council, a couple of months ago for a conditional use permit, and we did get that approved so that William could continue with his tree services on the parcel. And now we're coming through asking for the lot line adjustment so that William can continue with his business on his own parcel. The impervious coverage, as part of the conditional use, we were proposing to remove some of the impervious coverage. We were able to get the church parcel down to, I believe it was 25%. So we would still have a little overage for that one. And Williams' parcel would have been at 22.4%, I believe.
Okay, so this has you're not planning on any expansion of the church. At this point, you're just trying to
Moving the parcel line, the blue line, because the church owns the church and I would say the rectory building. So we're looking to adjust the blue line to the red line to where all of the church infrastructure would be on one lot and Williams would be on the second lot.
Okay, so and at this time, you really have no intentions of expanding the church? or the
No,
parking, or,
no,
because of course, we're already at an impervious soil.
right, right.
Okay. Anybody else have any questions or comments?
Yeah, I have a question. Staff has indicated the applicant could adjust the lot line to obtain more unimproved property with parcel 1.05 so that it does not exceed the maximum impervious coverage of 23% while maintaining less than 23% impervious coverage on parcel 0.101. How do you respond to that?
There is the potential that we could look at adjusting the red line towards the back to accommodate more open space onto the church parcel, but we did look at that earlier this week in the office, and there really isn't a way that we can get both parcels to be at 23%, so we would still have some that would be over.
Thank you.
Thank you.
Anybody else? So I have just a couple. Typically, and I would go out and look at this property, but I just didn't get to this time. So, and today would have been a perfect day. But do you typically have water laying in this area, in this field or the adjacent fields? Not necessarily after a monsoon like we had today, but
Right.
after rainstorms.
I believe it's fairly dry. There is the wetland, or not the wetland, but the stormwater facility that's there.
Mm-hmm.
So I believe there's,
That seems to handle
yeah.
things.
Yeah.
Okay. All right. Anybody else? Looks like you're done.
Thank you.
you.
Is there anyone else that would like to speak in favor of this application?
There's no one online at this time.
Thank you. Is there anyone that would like to speak in opposition of this application?
Again, no one online at this time.
Thank you. Seeing no one, the public hearing for application A-22-16 is now closed.
Okay, thank you. At this point, I'm just going to ask, but also I'm assuming we don't need a break because we just got started. Okay, so at this time, we are closing the public hearing, and I am now going to call to order the business meeting, and just as a matter of housekeeping, let's call the roll.
Yes, ma'am. Mr. Nichols?
Here.
Ms. Hudson?
Here.
Mr. Jenkins?
Here.
Mr. Cusick?
Here.
Ms. Denny?
Here.
Thank you. That's 5 present.
Okay, so first order of business is approval of the business meeting minutes for May 19th, 2002. I was not here, so of course I'll not vote.
Thank you.
I'll make a motion to approve the minutes of the May 19th, 2022 business meeting.
Second.
Okay, so we have a motion and a second. All in favor?
Aye.
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 Any nays? One absent. So having received unanimous positive votes, the minutes of May 19th, 22 are hereby approved. Next order of business is the notice of decisions for the May 19th, 22 meeting.
Yes, I'll make a motion to approve the notices of decisions for application A 22-12-13-14-15 of the May 19, 2022 Board of Adjustment meeting.
Okay, so we have a motion. Do we have a second?
Second.
We have a motion and a second for approval of the notices of decisions from May 19th, 22. Do you need me to repeat all of them? Okay. So we have a motion and a second. All in favor?
Aye.
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 Any nays? One absent. Having received unanimous positive votes, the notices of decision from May 19th, 22 are hereby approved. We have before us one issue under old business, which is Jody and Marie Parker, who had an application before us 2 years ago, in 1920, and they did come back before and asked for an extension, and they have returned and asked for another 1-year extension for on this project, which is I didn't have it before me, but it's I mean, I heard it, but it was a division. They divided their property, is my recollection.
Ms. Denny, just to clarify, this is a new property owner, so she is currently working to try to obtain a builder. She kind of inherited this property with the variances and is requesting to continue forward with those variances, but is asking for another year extension so that she has the opportunity to go forward and look for a builder herself.
Thank you for that clarification. Okay, so at this point, among us, do we have any discussion? Or I need a motion?
I'll make a motion that we grant an extension for application A 20-23 for a 1-year extension.
I second.
Okay, we have a motion and a second for a 1-year extension on variances for application A 2023. At this point, I think we should call the roll.
Yes, ma'am. Mr. Nichols?
I vote on A 20-23, and I vote to grant the extension. Failure to do so would create an exceptional practical difficulty.
Thank you. Mr. Cusick?
I vote yes on the motion per staff recommendation.
Thank you. Ms. Hudson?
I vote yes for the motion based off staff recommendation.
Thank you. Mr. Jenkins?
Yes, I vote yes in support of my motion.
Thank you. And Ms. Denny?
I'm going to vote yes, especially these times between COVID and availability of builders and cost of materials, and then throw in a new ownership. It has a very good reason why we should extend this.
Thank you. That's 5 in favor of the motion.
Having received unanimous positive votes, application A 2023 is hereby granted a 1-year extension to their variance. Okay, so moving along, we have before us the application for Calvary Church of the Nazarene. Do we have any discussion, comments, or a motion? I'm just going to mention that we have, obviously, from the planners, a recommendation to approve one aspect, which is the 150-foot lot width. And then, of course, we have a suggestion that we deny the impervious coverage. And so it's, whoever makes the motion or all as a group, we might decide if we want to handle them together or separately.
Well, I'll make a motion that we do them both together, if that's okay with everyone. So I make a motion for A-22-16. I vote to approve the road frontage variance of 86 feet and to approve the 23% impervious surface based off the public testimony.
It was 60, what was 64? Oh, yeah.
Scratch that. Okay. I vote to approve the road frontage variance of 64 feet and approve the 23% impervious surface based off the public testimony. I believe the removal of the restrictions would not seriously affect the neighboring properties, and the change of the parcels is a character of the surrounding area.
I'm sorry, I just have one question. Are you motioning to approve their proposal of 26.9% impervious coverage?
Let me read. Okay.
Or would it be easier to do one at a time? Mhm.
We'll do that one at a time. So for A-22-16, I vote to approve the road variance of 64 feet.
Okay, so we have a motion. Any discussion or a second?
Second.
We have a motion and second. When you're ready, call the roll.
Yes, ma'am. Mr. Nichols?
In connection with A-22-16, I vote to allow the lot line to be changed per staff recommendation. To fail to do so would create an exceptional practical difficulty.
Are you voting to approve the 64 feet lot width?
Yes.
Thank you. Mr. Jenkins?
I vote yes in support of application A-22-16, the 64-foot lot adjustment as recommended by the staff.
Thank you. Mr. Cusick?
I vote yes for application A-22-16 to approve the 64 lot width at the front building line per the staff recommendation. Fits within doesn't change the immediate vicinity and the hardship to allow this company to have its own property line.
Thank you. Ms. Hudson?
For A-22-16, I vote to approve the road frontage of the 64 feet based off the public testimony that we heard and off of staff recommendation. I believe the road frontage is in character of the surrounding property next to it.
Thank you. Ms. Denny?
On application A-22-16, I vote to approve the motion for a 64-foot lot width. Based on the recommendation of the planners, it seems that this, well, number one, there's plenty of land there, but it appears as though that this is not totally out of character for what's happening in that area. So, and I think I can see that it would be an exceptional practical difficulty otherwise, as they are trying to create another lot and separate the two properties. So yes.
Thank you, ma'am. That's 5 in favor of the motion.
So having received unanimous positive votes on application A-22-16, the application for a 64-foot lot width is hereby approved. So now we're going to need to address the impervious soil. And I just kind of wanted to make one comment. It was pointed out that there is a drainage area there.
Yeah, I agree. I mean, that stormwater management pond is for that whole site, so I mean, it just makes sense to, I mean, it handles that whole site. So I'll make a motion to approve the 26.9% impervious coverage for application A 22-16. Per the testimony tonight, they tried their best to did their due diligence to get the close as possible and not creating any additional variances within the property. And I believe, again, the hardship to allow this company to create its own property, maintains it, and like I stated previously, the stormwater management pond that exists on site now handles that entire site.
I'll second that.
Okay, so we have a motion and a second. When you're ready, call the roll.
Ma'am. Ms. Hudson?
I vote for A-2216. I vote to approve the 26.9 impervious surface. I believe that removing the restriction would not seriously affect the neighboring properties. There is a retention pond to the south of the property that would absorb the runoff water, and I believe the changes are in character of the surrounding area.
Thank you. Mr. Nichols?
Connection with A 22-16, I vote to approve the 26.9% impermeable surface. Failure to grant the variance would result in an economic hardship for the owner.
Thank you. Mr. Jenkins?
Yes, I vote in support of application A 22-16 in relationships to the 26.9% impervious surface coverage for two reasons. One, there is a retention pond that should more than handle any excessive drainage, and the fact that the applicant has made an effort to look at and consider any possible adjustment on their lot lines to handle this.
Thank you. Mr. Cusick?
I vote yes per my motion.
Thank you. Ms. Denny?
I'm going to vote yes. Based on the comments of the maker of the motion, most especially with regard to the stormwater management that is in place to cover all of the lots, so therefore yes.
Thank you. That's 5 in favor of the motion.
Having received unanimous positive votes, application A 2216, the request to increase the impervious soil to, and I think it's 29%, but 26.9%, I'm sorry, is hereby approved. So, looks like we have no further business, so I'm looking for a motion to adjourn.
Make a motion to adjourn.
I'll second it.
Motion is second. All in favor?
Aye.
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 Good night, everybody.
Thanks for using WebEx. Visit our website at www.webex.com.